Very good afternoon, everyone. It is my great pleasure to welcome our distinguished speaker and all the participants to the Express Certificate course on patents being conducted by the DPIIT-IPR Chair, IIT ISM Dhanbad, as a part of the certificate course in IPR under the norms put forward by Spriha. This initiative reflects our commitment to building knowledge and capacity in the field of intellectual property, especially patents. On day one, I extend a warm welcome to our distinguished speaker, Dr. Pankaj Kumar. Dr. Pankaj Kumar is DPIIT-IPR professor at the National Law University and Judicial Academy, Assam, with over 2 decades of experience in intellectual property rights. He holds a PhD in biotechnology, patents, master's degree in biotechnology and law, and an associateship in information science, patent informatics, and an LLB from the University of Delhi. A registered patent agent, he has facilitated filing of more than 500 IPR applications. Dr. Kumar has been actively engaged in training, advising, and supporting startups, MSMEs, and institutions in IP strategy, drafting, and policy. Okay. So mark your attendance and receive your certificates. We'll be sharing a Google form by the end of this session. Please make sure to fill it. Now, I request Dr. Pankaj to please continue with this session. Dr. Kumar, please proceed with your presentation. We are all eager to learn from your expertise.
Thank you, Mandavi. Thank you. It's a great opportunity to serve you people. Most of the times I served in startups, MSME, and educational institutions, but I think this is the hardly much of such opportunity to serve IITs. So, as you suggested, pre-filing, preparation, and filing to disposal of patent application, it covered a lot of things, and 1 hour is not sufficient to cover pre-filing and post-filing, such kind of things. So, let's see how I can fulfill your expectations. So please reconfirm whether the slide is moving. The slide is moving or not?
Yes, it is moving.
Okay, thank you. So see, there are different steps during the patenting. Or in fact, if we see the life cycle of inventions, patent is one of the stage, and other stage like ideation, creation, protection, maintenance, commercialization, then enforcement and incentivization and monetization. So if any of the stage is missing, the purpose will not serve, because an idea can change the life, but all ideas can't be worked out. All ideas may not be commercially viable. So if we have some successful creations like inventions fulfilling all such criteria, such inventions must be protected if the inventor or the concerned person interested to monetize out of their inventions, and particularly if the person want restrictions like no one else can do such commercialization of their invention without their prior consent. In such case, they compulsorily required patent protection. And grant of patent is not sufficient. We have to maintain such grant by renewal. And even such grant and renewal is not sufficient, we have to monetize. If we unable to monetize, then in such cases, there is hardly much motivation to such inventor to reinvest their funds, time, energy, resources to express their new ideas. So all such stages are essential. These are some of the FAQs. I am trying to cover all such FAQs in my presentations. Like why would anyone want a patent, or what are the patent rights, what is the patent period, what are the disadvantages of patent. Not only advantage, there are some disadvantages also. So subject matter of patent, what are the subject matter, what are non-patentable, patent life cycle, some crucial points which must be remembered by all the applicants, different steps of the patent application, idea, what next, what is NDA, what is IDF, what do you mean by prior search, and what are the benefits. So there are a number of questions. So let's see how many questions I'm able to convince you people. So this is a very generic questions. What is patent? This is a legal right. This is an exclusive right, so that a person may exclude others. The subject matter for patent is invention. It is granted to the applicant. After grant, such applicant considered a patentee. Such applicant or patentee may be inventor or
Excuse me,
their
sir.
assignee. Yes.
Excuse me, sir. I'm extremely sorry to interrupt you, but are you sharing your screen and presenting something? Because we are not able to see anything.
Okay. Just check whether slide is moving or not.
Oh, sir, it's not moving. We are not able to see any presentation.
Oh, say, just a moment.
It's visible now, sir. Thank you.
No, please confirm whether
Yes.
slide is moving or not. Whether slide is moving.
Not yet, sir. Can you try changing the page? We are not able to. I can see the fourth page.
Okay, slide is not moving at your end.
No, sir. It's moving now.
No, it's not moving, madam. We're not able to see the slides.
Please reconfirm whether slide is moving or not.
No, sir, it's not moving. Not visible at all.
Okay.
Hello.
Not moving, sir.
Okay, let me try again. So,
Yes, we
now
can
please
see now.
confirm.
Yeah.
Yes, sir.
We can.
Yes, sir.
Yes.
Okay, thank you. Thank you. So I was discussed so far the various stages of patent life cycle, including ideation, creation, protection, maintenance. So, and these are some of the FAQs, frequently asked question in the field of patenting. So, what do you mean by patent? This slide covers all such information. What do you mean by patent? What are the crucial aspects of the patent? And this is a legal exclusive rights, and the subject matter for patent is invention, and the applicant who apply may be inventor or their assignee. After grant called patentee, there are certain criteria to be considered invention patentable. These are patentability criteria. This is given for a limited period of time, that is 20 years from the date of filing or the priority, whichever is earlier, by the government. That means this is a territorial rights. We can't enforce our Indian patent in other countries until unless
Sorry
we have.
to interrupt, sir. I think
Yes,
screen share has stopped again. Would you please check it at your end?
then I have to check on my mobile. If, just give me a few seconds.
Yes, sir.
I'm moving the slide. Why this is not reflected there? Please reconfirm whether slide is moving or not.
Sir, it is not shared.
You are right. So why I'm all time sharing, but don't know why this is unshared. It's on.
It is shared now, sir.
But after a few seconds, it got
Yeah,
unshared.
we can.
Okay, please inform me once there is an issue again. So we covered. Hopefully, 3 certificate is visible on the screen.
So your first page of your slide is visible.
No, this is there are 3 certificates. These are 3 patent certificates on the screen. Whether it's visible?
So the very first page of your slide is visible.
Uh, request, madam. Host can receive. Can you operate from your
Now
send
we can.
to the correct task repeat and you can operate no unnecessary waste of time. So that
Sure, sir.
I'm requesting host to collect the data from the PPT from resource person and you can operate if
Yes,
sir has some technical glitches.
Can you confirm
Please.
now whether slide is moving or not?
yes, sir. It's moving. Yeah.
Okay. So see, just like another assets, patented inventions are considered an assets like property. We can use the property like we can live, we can sell, we can rent it out, we can do mortgage, we can abandon. Similarly, we can do such things with our patent rights. We can use the patent rights, we can sell the patent rights like assignment, we can rent it out like licensing arrangement, we can also mortgage and abandon such patent. So these are some of the patent rights. These are mentioned under Section 48 of the Indian Patent Act. In case of product, right to making, using, offering for sale, selling, importing for those purposes that products. All these are the rights of patentee. So invention may be defined like a new product or process. So one thing is clear, invention may be a product, invention may be a process. And in single application, we can claim both the product and the process. If like we can divide the application, one for product, another for process. So there is a word new. So such product or process must be new. So at the time of filing, novelty must be maintained for such product or process. Further involving an inventive step. So novelty is not sufficient. Along with the novelty, we have to prove there are some inventiveness. So it is not obvious and capable of industrial application. That means there is certain utility, industrial applications of that invention. So the criteria for invention may be derived from the definition of invention, and these are novelty, inventive step, and utility. These are some of the inventions. These are some of the pictures of earlier inventions, all inventions. You can see some very simple inventions and there are some complex inventions here. Even paper clips, ballpoint pen, all these are considered invention for the purpose of patent. And many times people use the word discovery. Invention and discovery, these are two different things. I'm not going in detail. simply you can see there is a human intervention in invention, but in discovery, these are gift of God. We can find such things in nature. So new inventions and innovations, improving lives, like faster computers, more powerful mobile phone, safer transportation, cleaner energy, improved medical treatment. So these are innovations in the field. See this example, you can appreciate the power of patent. The inventor licensed the system of can to Coca-Cola and royalty fixed 1/10 of a penny per can. And during the period of validity of the patent, the inventor obtained 1,48,000 UK pound on royalties. So we can say an idea can change your life if such idea have commercial viability. If we have legally protected such things, we can exclude others not to use it. Hopefully slide is moving. Is there any issue?
No issue.
Yes, sir, it's moving.
Please go ahead,
Yeah.
sir.
Okay, thank you. So similarly, another case, Facebook buys WhatsApp for $19 million. So these are some old, you can appreciate the monetization and commercialization of patented inventions. So why patent? It protects key technologies, inventions, provides exclusivity to partners. That's why startups based on invention prosper, incentivize commercialization, and generates value. So these are some of the benefits. It attracts venture capitalists. You can defend yourself from the competitors that you have rights over your invention. You have already filed the application for patent or you got the patent in your invention. So you can stop theft by larger rivals, no matter who is the opposite party. If you have rights, you can exclude anyone. If anyone interested in your patented invention, you can uh, use the options like assignment or licensing. You can do cross licensing, exclusive licensing. So it gives you a strong market position and competitive advantages if having such patent rights. It helps striking a license deal. Patentee may get profit margin for a valuable patented invention. They can expand the market based on their patented invention. It helps a person like a startup to form joint venture, R&D partnership. Patentee may increase the chances that a startup will be acquired based on the value of their patented invention. So these are the importance, particularly if we talk about innovation and creation. New ideas and solutions always encouraged in the society. And that's why the government policy to encourage innovations, to encourage, promote such innovative ideas. So IP transform creativity into impact. Regarding commercial viability and monetization, we may monetize our such patented invention by technology transfer, licensing, selling, franchising. We can generate revenue and reinvest further in our new ideas. And so that the life cycle of invention may complete. Regarding legal protection, and if having patented invention, we can prevent unfair practices like counterfeiting. Patentee may get recognition and incentive. There are several government schemes, IPR awards. Such patentee may collaborate with the concerned companies, manufacture entities to market their patented invention in the concerned market. Regarding education, career, and opportunities, there are so many KPOs, LPOs, and IPOs where most of the countries are very much interested in Indian market and utilize the services under such knowledge process outsourcing, legal process outsourcing, or IPOs. So valuable for competitive exams, integral to academic. In year 2013, UGC wrote a letter to all the universities in India to include one paper on IPR in their course curriculum. So these are the options with the inventor. If inventor like, they can use their invention in open public domain for free use. If the person like, they can protect their invention by concern IPR. They may do commercialization, licensing, in barter rights they can enjoy. So these are some of the options with the right holder. So why patent matter in business? If you don't have patented your invention, so see what you lose. You lose your competition, lose to duplicates, lose to importer, loss in export. So you have no legal rights on your invention at all. So this is a compulsory requirement. This is not an option. In copyright, in trademarks, there is no such compulsory requirement to protect it by formal registration. But in case of invention, we have no choice. We have to protect it. These are the objectives: to get recognition, to get reward, to protect your invention, establish your supremacy in the field of particular invention, earning tangible profits, and intangible capital creation, realization of IP value. These are the some of the major objectives of patent protection. So in US Constitution, Congress shall have power to promote the progress of science and useful art by securing for limited time to authors and inventors the exclusive right to their respective writing and discoveries. Monopoly, this is a negative word, but in certain cases, particularly in case of IP, this is a necessary evil. So IPR here are exclusive rights granted by government to regulate the market. These are some of the quotations by our Minister Sri Piyush Goyal. Technology and ideas serve as the twin engine of growth, with the IP design acting as the fuel that powers this engine. And CGPDTM Sri Unnat P. Pandit said, IP is the fuel that drives innovation and creativity. Protect it. So creation and innovation need your time, your energy and efforts. If we don't protect it, anyone can use it for their commercial benefits. So get paid every time someone reproduce your expressed idea. Further, for the National Institutional Ranking Framework, there are certain marks for filing applications for patent, for granted patents, for licensed patent. Sometimes we see such news like only after getting patents, you will awarded a PhD degree. This is not feasible. This is not practical. So let's see. So inventing, how we can invent. While carrying out research or project, we must identify some problem. We have to highlight what are the problem exist. If we solve such problem technically, then we can consider our such solution for that problem as an invention. It may be a process. It may be a method. And for such kind of process, method, inventions, we can apply for patent. Many times there are cases of serendipity, like in this case, Velcro. Velcro is a brand name. The generic name is fastener. So you can see there are so many such cases. So idea may be come through any such incidents. In fact, dynamite This is also one of the case of serendipity. So it is used not only for destruction but constructions also. So there are so many casualties during World War II, and see, there is a concept here, Nobel Prize, as per the name of the inventor Alfred Nobel. So see the revenue he earned through his patented invention, and one of the portion of such monetization he deposit in the bank, and whatever the interest that divided in multiple Nobel Prize. One of the first Nobel Prize is Nobel Peace Prize. Again, microwave, X-ray, all these are example of serendipity inventions. This is innovation. Innovation may consist of multiple inventions. Landline phone to a smartphone. Innovation, see the journey of television. So there are very few patents granted, not more than 40%. Around 60% patent applications are either rejected or abandoned, and hardly 40% patent applications considered for grant. And if we talk about commercializations, it's a hardly 4 to 5% patented invention who got the commercialization. So this is not easy to commercialize your ideas. We have to work very hard. First, we have to draft it properly, getting the patent, maintaining the patent, successfully transfer the technology. I think there must be someone there to admit the people. Okay. So these are some of the news regarding patent over such inventions which are some sort of bioresource or traditional knowledge associated with such bioresource. Recently, there are very few such cases, but earlier, like 1 decade ago, there are so many such cases highlighted in the media. Like neem, haldi, basmati, there are so many things which people utilize to solve some problems. There is a issue that such things sometimes not well documented, and patent office don't have such information codified with their database, and due to lack of such tools, they wrongly accept some of such applications novel and granted the patent. These are wrong patent. Today, we have guidelines for examination Ayush related invention. This document is published today only, and you can access this document on IP India website. So far, we know an invention which in effect is traditional knowledge or duplication of known properties of traditionally known component has been made non-patentable under section 3P. This is a guideline booklet for examination of Ayush related inventions, so that patent office, the examiner there examines such kind of applications as per this guideline and minimize such wrong granting on this subject. Section 2 of the Patent Act defines the word invention. This is the subject matter for patent. So inventing and patenting. While carrying out research project for, you have to identify some problem, highlight the solution which solves such problem. You have to fulfill at least 3 criteria. First criteria is novelty. Novelty means new invention. Our invention must be new. What do you mean by new? It means any invention or technology which has not been anticipated by publication in any document or used in the country So it's neither the publication nor the use, or elsewhere in the world. Before the date of filing of a patent application with complete specification. That means before filing a complete specification for your patent, such information must not be published in any document, must not be used anywhere in the world. So novelty is not judged in the individual country or the respective countries, but worldwide. That is, the subject matter has not fallen in public domain, or that it doesn't form part of the state of the art. So we can establish novelty of our invention. And second criteria is inventive step. This criteria is compulsorily required to consider your invention patentable. Inventive step means a feature of an invention that involves technical advance as compared to existing knowledge. So your invention must be technically advanced as compared to prior art, or having economic significance. Either technical advancement or economical, or both. Both here, Sone pe Suhaga, and that makes the invention not obvious to a person skilled in the art. Although person skilled in the art is not defined in the act, but there is a term we import from US, PHOSITA, PHOSITA, person having ordinary skill in the art. So we have to check whether our invention have either the technical advance or economic significance, either of these two or both, and even if it fulfill either of this technical advancement or economic significance, still that invention must be not obvious to a person skilled in the art. And third criteria is utility. There is hardly any such objections of utility raised by patent office. Most of the times we receive objection in examination report regarding novelty and inventive step. So it means in relation to an invention, invention is capable of being made or used in the industry. Either the invention have capability of being made in the industry or used in the industry. So who can invent? Anyone can invent. So set a goal, dream, imagine, write it down, experiment, develop, modify, construct your invention. Many times your invention is a trade secret. Now it's your property. It's up to you whether you want to disclose this trade secret in public or not. So there are options. Either you may go for patent or publish it, or maintain it as a trade secret. Who can fight? Prima facie is the inventor who invents something, but as per the institutional arrangement, might be applicant is the institute. So either alone or jointly, such people may file a patent application. So by any person claiming to be true and first inventor, by any person being the assignee of person claiming to be true and first inventor. So as per the institutional arrangement, might be that inventor need to assign their patent rights or rights in their invention to their institution, or by the legal representative of any deceased person who can immediately before his death is entitled to make such application. So most of the times in institutional case, it's the institute only who is the applicant, and rest all the inventors are recognized as the inventor. And nowadays there are certificates generated for inventors also as per the request, certificate of inventorship. So these are some simple patents which are already granted, and there are some patent number also mentions. People are filing patent applications for such simple uh, products like using plastic waste and other waste. They are forming the bricks using such waste material. Sometimes they use the waste material and prepare some wooden briquettes. So idea, what next? Generally, what next? Once we have some ideas, we thought we can monetize our ideas, but it's not so easy. We do one mistake at this moment. Many times we discuss our ideas publicly with our friends and see first come first serve basis. If such ideas leak, if such things become part of public domain, we lose the novelty. So we can't get the patent over such kind of invention. And patent protection is particularly useful for costly to invent, but cheap to imitate ideas. So this is the strategy. Which kind of invention we should go for patent and which kind of patent, which kind of invention we keep as a trade secrets or disclosed by publication. So in order to file applications, we have to study for patentability. And during such patentability study, we have to focus on such criteria like novelty and inventive step. So in order to maintain such novelty, we must not disclose our such invention to anyone. So sometimes we receive such message, क्या आप पेटेंट सर्च कर पेटेंट नंबर की लिस्ट मेरे को भेज सकते हैं? So the person willing to share their invention disclosure. So they generally don't bother non-disclosure agreement. So once you share the disclosure form or data set, they generally fill all such documents and submit to you. So patent rights are the ownership right to the applicant or the patentee have over inventions that the person create as a result of an original idea. So these are non-disclosure agreement and invention disclosure form. Ideally or theoretically, we discuss non-disclosure agreement so that the person to whom such inventors or applicant disclosing their invention may not misappropriate such information to pass such information further or filing such applications in the name of someone else. So before filing any applications, we need some homework like stabilizing the novelty and inventiveness. And to establish such novelty and inventiveness, we have to do prior art search, whether such invention is already available in public domain or not. There is a limitation of such prior art tools. What information is codified in such database, only such information we can find during this search. But the information which is not codified might be in some other languages, might be at remote places, not accessible by public in general. We may not access such prior art. So theoretically, such applications are not patentable if such information is already exist. Published information before the filing date of application for patent, these are called prior art, undertake to ascertain whether an invention is new and non-obvious or not. And that's why this is called patentability criteria, stabilizing novelty and inventiveness. So these are some of the benefits of prior art search. Uncovered knowledge existing prior to the filing invention for patent. So prior search will help distinguish between what is already known, prior art, and what is new art. So we have to differentiate, we have to highlight in the specification what are the problem exist. We have to mention background of the invention, prior art of the invention, objective of the invention, and detailed description of our invention along with the application. So during prior art, we mention what are the problems. the prior art not be limited to but including patent applications, scientific thesis, industrial know-how. So it includes every information what is exist publicly before filing our patent application. It may be patent information made, maybe non-patent literature, including scientific thesis, industrial know-how. So once prior art is obtained, an inventor will get an accurate idea of just how novel and how non-obvious the invention, which we are going to apply for patent. Afterward, the inventor can accordingly rework the invention for patent application. So it helps the applicant or the inventor or the agent to redraft or reinvent such things for the purpose of patent. And the secondary benefits such search is that an inventor can also use such a search to understand the prevailing state of art in his field of research. So it gives an idea as to how the future scope of research could be. We can establish the trend of inventions in that particular field of invention. Who are the key players? Who are the key applicants? Who are the key inventors? What is the trend of patenting such kind of invention? So once we file any such application, actually we have to enter the data and information over the portal. So there is a database, patent database. Every country maintains such national patent database. With the help of data field like title, abstract, complete specification, application number or other number like publication number, patent number, and the name of applicant, name of inventor, country, applicant country, the address. With such data field, we can search such applications. Here in PAS in India, Indian Patent Advanced Search System, there are options, published applications and granted applications. These are those published applications which are yet to be granted. And once such applications granted, there is a option granted. So we have to tick. We can tick both published and granted. And with the help of such keywords in particular search field, we can find the relevant hits. These are some of the key patent database like Indian Patent Office INPAS, USPTO for US Patent Office, SpaceNet for European Patent Office, WIPO for International Patent Database, Patent Scope. There are some other free database, google.com/patents. You will get a great service by such Google Patents, translating such applications in English language, patent claims, free patents online, India patents. There are some database also like Delphi and Derwent, Thomson Innovation, where we have some facilities like they redraft field of the invention or abstract so that we can find with some common words the relevant patent applications. We have around 21 field of invention like agrochemical, biotech, chemical, civil, communication, electrical, electronics, food, general engineering, mechanical engineering, pharmaceutical, textile, computer science, physics, biochemistry, etc. Again, these are the various status like in process or granted or refused or abandoned or withdrawn. So we can do some research based on such a status and based on that particular field of invention. What is the trend? Who are the key players? So these are some of the common mistakes made by inventors, publishing the invention before filing. Many times we experience people came to us for filing patent application and they excited, they're happy to share this information that they have published their such research article in so and so journal. They do academic papers, blog post, presentation, or in social media disclosure. That way they are killing their novelty. Nowadays, under Form 31, we have grace period of 1 year to request waiver of such objection of novelty for this term, 12 months. Using the invention in public or commercially before filing, these are the common mistakes. Waiting until the invention is fully developed. So there are options, provisional filing. So no need to wait until the invention is fully developed. First come, first serve basis. If anyone file a provisional application, that person get 12 months time to complete after provisional. If you fail to complete it within 12 months, you can file a fresh application. The benefit is you no need to pay further filing complete after provisional, and you can enjoy prior rights, priority. Sometimes it is noticed that many inventors delay filing until the product is market ready. So there is a risk, might be such invention leaked in public, or might be someone else files the application. So this increases the risk of leakage, duplication, or being scooped by competitor. So best practice is file early, even if it is not just a provisional application. Keep invention detail confidential until filing. Use NDA non-disclosure agreement when discussing with other. Consult IP professional to strategize filing across jurisdiction. There may be many countries who are having such commercial viability for your invention. So earlier, Dr. R.A. Maselkar, ex-Director General of CSIR, said, publish and perish, patent and prosper. If we publish it, we can't exclude others to monetize our invention. But if we patent it, we can publish even after patent and get prosperity. So these are a list of inventions which are not patentable. I'm skipping this slide. Again, I'm skipping what are not the subject matter of patent. We can see it under section 3 and 4. So these are 4 patent office: Calcutta, Delhi, Mumbai and Chennai. Calcutta is the head office for patent, and rest are branch offices. And this is the territorial jurisdiction. They are nearby states covered under territorial jurisdiction of such patent offices. And this is the hierarchy. There is one CG, Controller General. Under him, there are joint controllers, deputy controllers, assistant controllers, and lastly, the examiner. Every such assistant controller have a team of examiner, and all such are as per the field of invention. So we must remember some points like first protect, then publish. That means first file the patent application, then go for publication. Don't wait for patent grant, but at least file the complete specification before doing such publication. Otherwise, we may require Form 31 to waive off such objection regarding novelty. Rights are territorial, so we have to keep it in mind that such rights are territorial in nature. So where they are potential, we have to file such application. Registration is done by government in all such member countries. Priority, if any. So see, if we must use the priority claim rights for limited period of time. So such patent rights are given for 20 years, and such time counts from date of filing or the priority whichever is earlier. And sometimes it takes more than 5 years to grant such patent. So maximum time the applicant may enjoy like 20 minus 5, 15 years, and subject to renew it every year. And there is no any automatic relief if we don't file the patent application. Even if we file, we can claim infringement rights only after the grant. So we have to wait for grant in order to file such infringement suit. Renewal every year, we can do multiple year renewal in one go. If we do it for more than 4 years, then there is 10% discount. Appointment of patent agent is not compulsory, but applicant can sign the document and file himself. It is not recommended because there are certain stages, and such government fee is not refundable. And even if such patent application is published by patent office, we our subsequent patent application or fresh patent application on the same disclosure not considered patentable due to lack of novelty. Our earlier patent applications kills the novelty feature of our subsequent patent applications. So this is the roadmap. Like, we have to sign NDA, although this is not a compulsory requirement as by the patent office. We have to do patentability or prior search. Again, this is not a compulsory requirement by patent office. Patent drafting, if we do poor drafting, we can claim very narrowly. So it's a hardly any benefits of such patent, even if such patent is granted. Patent filing, obviously, this is compulsory. If we need patent, we have to file it. So there are options: online filing, e-filing, and offline filing. In offline filing, we have to pay 10% extra. Government publish our all such patent applications. So this is default. After expiry of 18 months from the filing, all such applications got published without any formal request for publication or paying such government fee. But if we need prior publication, we have to request for early publication. Only after publication, there is an examination. And examination is not optional. So we have to request for examination, and the maximum time is 36 months. And within 36 months, we have to request for examination. Otherwise, our such application will considered abandoned. So these are the minimum documents required for patent filing: Form 1 and Form 2. Form 1, we have to enter the data like who is the applicant, who are the inventor, what is the title of invention, such basic details. And under Form 2, there is a specification, the invention disclosure. And subsequently, the request for early publication, which is optional, request for examination. If there is a agent, then we have to arrange authority to agent or power of agent, a special power of attorney. Stamp duty vary state to state. So 100 to 500 rupees, it depends on the state. Proof of right, if applicant is not the inventor, inventor and applicant are two different entities. In that case, applicant need to arrange some assignment document from inventor, and under Form 1, there is a paragraph for this assignment. We, the inventor in this application, assigning our such rights to the applicant, and name of inventor, sign. This paragraph is sufficient for proof of right. It will work as an assignment document. And in case there is a priority document, we need verified English certified copy of such priority document. And there are some other forms which are depend case to case basis. So we have these options: e-filing and offline filing. So all such links are may be accessed by IP India website. This is the homepage of that portal. You can see all such options: patent, design, trademark, GI. And in the box, see comprehensive e-filing, public search, dynamic utilities. Under comprehensive e-filing, we have options like e-filing patent, e-filing trademark, e-filing design. Similarly, in public search, there are patent, trademark, design, status, there are patent, design. We can check the status of patent with the help of application number. This is just like PNR. We can search patent database in this patent search option. We can file e-filing under this comprehensive e-filing. So anyone can create this login account with the help of your username and password. You can log in. You can file these forms. Once you file the application, this window is open for clarification whether our invention used any bioresources or not. If there is any bioresources, we need prior approval from National Biodiversity Authority. We can ignore it. Even if we use the bioresources, we can submit this prior approval from NBA later. So this is the form. We have to enter the data like type of application. There are total 9 types of patent application. We have to select our applications like ordinary application. Again, type of specification. We have two options: provisional application or complete, as per the kind of applications like provisional or complete. Whether we have complete invention or we have to wait for complete, we can select either provisional or complete. Regarding number of page of specification, number of claim, number of page of claim, number of page for abstract, number of drawing if any, sequence listing if any, priority if any, we have to enter the figures here, the numbers here, and title of invention. The title should be within 15 words. It must not be exceeds 15 words. Address for service. Such address for service must be an Indian address so that patent office can communicate to the applicant. Generally, agent address is preferred over such address for service. But if applicant like, they can use their own address here. Rest state, which states from the applicant is from which state, and the telephone number, fax number, email ID, alternate email ID, abstract. We have to copy paste all such information in our specification, like what are the claims, what are the abstract, what is the title, all such information. So we can select type of application, C, conventional, divisional, ordinary, divisional, conventional, divisional PCT, ordinary application, patent of edition, patent PCT national phase. So we have to select it here. After that, see the type of specification, provisional or complete. We have to select again whether our application is provisional or complete. Further, we can add here priorities if any. We can add applicant. It may be more than one applicant. Again, inventor. If both applicant and inventor are same, maybe different, maybe more than one inventor. So abstract, description and claim. We have to enter such information in the box, description box, claim box, and we can add the applicant further. If inventors same as the applicant, we can copy by select the option. And lastly, declaration by the applicant. These are certain declaration. We have to select particular declaration which is applicable in this case. And lastly, in bottom C, there are options Form 9, Form 18, and Form 28. So Form 9 is for early request for publication, request for early publication, and Form 18 that is for request for ordinary examination, and Form 28 is for if we want some benefits under government scheme for educational institution or a startup or MSME, we have to submit the supporting documents over this Form 28 to get 80% discount in government fee. And further, proof of right, power of attorney, priority document are required to be submitted original. Lastly, we have to select, I agree that above information submitted by the applicant or the agent is true. So we need to save this document. After saving this document, we can generate the report, and the report is in the form of form number 1. So along with the form number 1, we can upload such documents like complete specification, declaration of inventorship, drawing, evidence of registration under MSME Act, or recognition of educational institutions or DPIIT, recognize a startup, figure of abstract, form 1, priority document, proof of right. So there are multiple documents. Minimum documents required are form 1 and complete specification or provisional specification as per the kind of patent application. So these are two essential document, specification and form number 1. Rest document we can submit later on also. So this is the report, form 1. What information we already entered at the portal, we can create this form 1. Applicant information, inventor information, title of the invention, and address for service. Other information like priority data, PCT data, file, divisional patent application data. So in most of such cases, like in our ordinary patent applications regarding paragraph 5 to 8, we don't have any information. So we can write nil information, not applicable. 5 to 8, not applicable. Lastly, declaration by the inventor. So this is the statement I or we, the above named inventor, is or are the true and first inventor for this invention and declare that the applicant herein is or are my or our assignee or legal representative. So along with the name of the inventor and the sign of the inventor, this document work as a proof of right or assignment document in behalf of inventors to applicant. So these are the declaration by the applicant. We can select yes or no as per the applicability. And lastly, the attachment. Minimum attachment are specification and form 1. Rest it depends. If we have ready drawings, priority document. So these are optional. In some case, we have such documents and ordinarily we don't have such documents in all such applications. Even we can submit such documents later on after filing the patent application. So we have to select the concerned documents along with form 1, and regarding form 2, that is the patent specification. On the cover page, we have to mention title of the invention and the detail of applicant. And from the second page, we have to mention such information like, again, title of the invention, field of the invention, background of the invention, objective of the invention, summary of the invention, description of the invention, embodiment, brief description, detailed description, advantages. And finally, from the first page, next page, we have to claim what we are claiming under this patent application. Up to 10 claims are free under the standard fee, and up to 30 pages are considered along with the claim in the patent specification. Subsequent page and subsequent claim after 30 pages in a specification and more than 10 claims, subsequent claims and such subsequent page require additional government fee. This is power of attorney. And form 3. Most of the case in ordinary applications, we have nil information. So earlier we have to file this form along with this nil information. But nowadays we can ignore this form 3 until patent office asks such information. And within 1 month of such requirement, we have to submit form 3 with such data, no matter whether nil or some other information we have. Regarding assignment and proof of right, we already discussed that within 6 months we have to submit this proof of right to patent office, and this is the same form 1, that a statement that inventor have assigned their invention to the applicant. It will work as a proof of right. So this is form 5. This is also generated online. We have to enter the data over the portal. So once we prepare this application, there are options to digitally sign the document. All documents need to be digitally signed before submission. And we have 2 options, DSC and e-sign. So you can opt any of such options, either DSC or e-sign. As soon you submit the application, you have to pay government fee. Once you pay the government fee, you get this receipt. This receipt is called CBR receipt, casebook receipt. And in this receipt, you can see the application number, amount paid, CBR number, name of form, and the title of invention. So all such basic information is covered on this slip. And with the help of this application number, you can track the status of your application, just like we use PNR to check the status. And this is AFR, application filing receipt. This is similar to CBR receipt, but it mentions some more data like name of the applicant, the address of the applicant, and type of patent application, priority numbers, if any, priority date, if any, priority country, if any. So there are some more information over this application filing receipt. It also suggests if this application is a provisional, then you have to complete it within 12 months. It also mentions if you want to withdraw the application, you can do it within 15 months from the date of priority or date of filing, whichever is earlier. If we miss this timeline, then after expiry of 18 months, it will automatically publish. So there is a significance of patent number. Such patent, this is patent application number. So patent application number are 12-digit number. First 4 digit indicates year of filing. Next 5th digit indicates jurisdiction, whether Delhi, Mumbai, Calcutta, Chennai. So 1 for Delhi, 2 for Mumbai, 3 for Calcutta, 4 for Chennai. 6th digit that indicates type of application. 1 for ordinary, 2 for ordinary divisional, 3 for ordinary patent of edition, 4 for convention, 5 for conventional application, so on. And rest 6th digit indicates the serial number. And such serial number applicable to all patent office in India. So this is the significance of a patent application number. Year, jurisdiction, type, and the serial number. So these are 12-digit number for patent application. Patent grant, after grant of patent, we have patent number. So patent number is different than patent application number. But this is not so in case of design application and trademark applications. Whatever the application number, the same number we used even after grant. And this is called trademark application number or trademark number, or similarly design number. These are the government fee. So for natural person and MSME educational institutions, we have 80% discount. Government fee 1600 at the first level. If we interested to file early publication request, then we have to pay optionally 2500 rupees. And request for examination, this is compulsory step. Otherwise, after expiry of 36 months, such application got abandoned by patent office. So government fee is 4000, and for other, the government fee is 5 times. So it's not 4000, it's 8000 rupees. So this is mistakenly 4000 here. So for educational institutions, earlier the government fee is 8000. After 80% discount, now it's 1600. Request for examination 20,000. Now it's 4,000. Request for early publication earlier 12,500. Now it's 2,500. So educational institution may retain the ownership on IP created by the employee during the employment using their infrastructure. So as per the institutional policy, it may vary institute to institute. There are certain government schemes like TISC arrangement, where you may get professionals like IP facilitator, patent facilitator. They can't charge you any single penny regarding their professional charges. Their charges will be reimbursed by patent office directly. You have to pay only government fee. So ideally for educational institution under Kapila, you see there is no cost because government fee is reimbursed by government under this Kapila scheme, and professional charges you can adjust through TISC center. So there is no any cost for such patent if we merge both this TISC scheme and Kapila scheme. For a startup, similarly, there is another scheme, SIPP. This is overall process. Once we file any application, it has to be published. Next, the examination. There is examination report. We have to reply such examination report within 6 months. If granted, we have to maintain it. If there is a remaining objections, maybe subsequent examination report, or lastly, maybe hearing. Publications we discussed, we have to pay 2,500 for educational institutions and for small entities on form number 5. This is the portal where you can check the status of patent with the help of your patent application number. We can do patent search also. Once the patent published, our application published, it's not the patent grant, it's the patent application only. So all such information got published over the portal in gazettes. So these are PDF files. You can see name of the applicant, title of the invention, and there are some classification number, abstract also. So here, with the help of your application number, you can check the application status. These are the information reflect once you use the application status. You can see application number, type of application, date of filing, applicant name, title of invention, field of invention, email as per the record, additional email if any, priority date if any, and request for examination date, publication date, first examination report date, date of certificate, post grant journal date, reply to IPR date, and final the status granted application and patent number so and so. See, patent number and application number, these are two different numbers. Now there are options e-register, orders, and view document. You can access further documents concerned to that particular application or particular patent. These are the documents exchanged between agent and the office. So whatever document agent upload on the portal, all such document reflected here. Anyone can access all such documents without any cost. You need only patent application number. With the help of that patent application number, you can check all such documents. So you can use this database, patent database. So you can find the application number with the help of keywords, with the help of field of invention, date of filing, the title of invention, the applicant, their address, date of publication, all such documents. So this is overall examination procedure. Request for examination, examination report. Within 6 months, we have to reply for examination report. Maybe there is a hearing, and lastly, disposal of the application by means of either acceptance or rejection. Examination request is compulsory. We have to request it on formal prescribed forms along with the prescribed fee. It varies person to person. So under form 18, we can file it. For a small entity, it's 4,000, and for other, it's 20,000. If we do offline request, then we have to pay 10% extra. Over the portal, we can use the application number. We can generate this form 18. This is for request or express request for examination. The government fee for express request for examination is double than the normal request. In some case, people change the mind in the last moment, and sometime after expiry of this 36 months, that they have to request for examination. And after expiry of such timeline, 36 months, see the option, we can request for extension at the rate 10,000 per month for a small entity. And for large entity, the government pays 50,000 rupees per month. So if we delayed by 6 months, the government fee would be 60,000 for a small entity, and for large entity, it would be 3 lakh rupees. So if we miss such deadlines, we have to pay extra by such petitions. So after requesting such examination request, there are issuance of first examination report. As name indicate, first examination report might be There are some subsequent examination report, like second examination report or some other office section. So under such examination, they check that patentability criteria which we discussed, like novelty, inventiveness, industrial application, whether such invention may be considered patentable or not as per the law, particularly section 3 and section 4. So controller allows such applications to the concerned examiner, and examiner submit their reports to the controller, and within 1 month of such submissions, controller arrange a copy of such examination report to the applicant or the agent. These are some common objections based on such common section in the Patent Act, like under section 10(4)(d). Source and geographical origin of the biomaterial used to prepare the invention are not indicated in the specification, so such information are essential in the specification. Later, we have to amend our application mentioning such details, source and geographical origin of such biomaterial. Regarding inventiveness, application doesn't constitute an invention under section so-and-so 2(1)(j). The claim of the instant application lacked inventive step, none obvious in view of the cited prior art document. Invention doesn't reflect any technical advancement in the subject, and the claimed invention is not patentable for lacking in inventive step under section 2(1)(j). So these are some of the raised objects in their FER. I just copy paste all such common objections in this table along with the concern section. So these are the common sections: 10(4)(2)(d), 2(1)(j), 3(d), 3(e), 3(i), 3(p), and 59. So most of the times you see these are the common objections mentions in examination report, like claim define new form of known substance which is already disclosed in prior art. Claim are no clear, synergistic, and comparative data of this claimed composition and also with prior art. Hence, claim fall within the scope of clause E of section 3. Accordingly, we have to redraft our claims and further add more information in the specification, and many times controller object on further addition. They need, you have to request for amendment, and again on formal request along with the prescribed form number 13 and with the prescribed fee, we have to revise such documents, patent specification and patent claims. Again, the objection C, claim relates to a process like medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment to human being or animal to render them free of disease or to increase their economic value or that of their product. Long back, the format of this examination report is like this: serial number 1, 2, 3, 4, 5, 6, objections, so and so. Nowadays, the format is little different. So nowadays, see the format. This is the new format. Under that, they highlight particularly novelty, whether yes or no, inventive steps, whether yes or no, industrial application, whether yes or no. So whether our application comply such requirement of novelty, inventive step, and industrial application. Further, they mentions the concern section 3 related subsections in this table. Like in this case, they mentions D, claim 224, attack section 3D. Further, they mentions detailed list of documents which are citations, prior art citations. So that means it seems such citations relates to similar invention. So we have to differentiate our invention from such citation. How our invention is different than D1, how our invention is different than D2, D3, D4. So there are some patent literature and non-patent literature. They mentions also citations so that we can differentiate our invention from such mention citation. Regarding inventive steps, similarly regarding novelty, they mentions such paragraphs that how D1 is relevant to our invention so that we can differentiate. If we require, we can arrange the full document either online, or if we have any problem, we can request the concerned examiner or controller to arrange such full text cited document. So these are the objections. I just mentioned some screenshot of this examination report. Other requirement, formal requirement like endorsement on form 5, we need to submit proof of right. So name of the controller and the last date of filing the response of examination report after 6 months. So these are some of the examination report. So you can see there are two parts of the examination reports. One is technical and another is formal. Under technical, we have to deal with different sections of the Patent Act. We have to see the wordings of the claim so that we can draft and redraft it as per the requirement. We have to differentiate our work from the cited work. And under formal objections, we have to arrange formal drawings, formal documents like assignment, power of attorney, petitions, etc. So these are two different kinds of objections, technical and formal. So as per the kind of inventions, whether fall under electronic or computer or mechanical, they are concerned objections. Under chemical inventions, there are different kinds of objections. Similarly, in biotech inventions, there are some different sections applicable. So sometimes we fail to manage some formal documents like proof of right or certified copy of priority document or power of attorney. So we can request petition under the concerned rules along with the prescribed forms and prescribed fee. So for all such different objections, we have to request for rebuttal along with our argument, our submissions. So in view of time paucity over this broad subject, I'm finding this presentation now. So please feel free to ask if you have any questions. Hello, are you there?
Thank you, sir, for an enlightening
Yes,
session
sir.
on patents.
We are there, sir.
Thank you, sir, for an enlightening session on patents, covering topics such as patentability, importance of patents, patent filing, and more. I'm sure participants have gained valuable insights from your expertise. Now that we are running short of time, the email ID has been shared with participants. And if they have any questions, they can ask over there, and their queries would be solved over there. Additionally, I would request all the participants to kindly turn on their camera for a brief moment. We'll take a group photo of a virtual session to capture everyone's participation. Also, the Google form link has been shared in the chat box. Please make sure that you fill in the Google form before you leave the session. Thanks a lot, sir. Thanks again.
Sir, meanwhile, I have one question.
Please.
Yeah. What is the purpose of the post-dating application, post-dating of the patent application? And how can we do that?
Very few cases we need such post dating. Actually, if we need more time to file our complete specification, we can post date our this earlier filed application. So if we file some um, earlier applications, we can request post date, like we can extend 6 month time so that we can have 6 months extra. But for such post dating, we have to pay. certain government fee. So we have two options. Either we have to file a fresh application or we can request for post-dating. So this is some sort of
Okay.
extension in time for filing the complete specification.
Apart from 12 months, you mean to say?
Yes, generally we have 12 months time to file complete after provisional. So in case if we need more time, we can use this post dating. We can request for new date for patent application date. So for that extension, we can request for post dating along with the prescribed form and prescribed fee.
Okay. Thank you, sir.
Thank you, sir. With this, we would like to conclude the session. Thanks a lot for your valuable insights. Once again,
Thank you for the opportunity. Actually, due to paucity of time, there is hardly much time for the participant to interact. I can understand. Okay. So may I leave now?
sure, sir. Once again, I
Thank
would
you.
like to request all the participants to please fill in the participation Google form so that your attendance could be noted and we can provide your certificate by the end of the course. Thanks a lot.